Jeff Hellinger back with Tom Beaver. Tom, would they like to get some of the counts dropped here? And I'm going to use the metaphor of maybe a half a loaf is better than a whole loaf if they can't get the entire thing dismissed.
Oh, absolutely. No question about it, because the very count you may be able to get dismissed for legal reasons might have been the count that the jury otherwise would convict on. It also narrows your defense in terms of what you've got to address in terms of the state's evidence. So absolutely any count that gets dismissed is helpful.
So this is now the longest we have ever gone on a session. It's 25 minutes before 6 o'clock. What is the expectation now? What's Judge Adams going to rule on here now?
Well, he has already ruled on the issue having to do with the chain of custody, that he's not going to grant the defense motion on that. That's not totally surprising. So he's already ruled on that. He may reserve his ruling till the morning on these motions of the demurrer, which is an objection to the actual charges themselves, meaning that the language of the charges are insufficient to put the defendant on notice and don't contain the material, don't contain the important elements of the offense. There will be also a motion to dismiss that's separate and apart from that, saying that the evidence is insufficient to prove the case and no reasonable jury could convict.
What's your sense of how this plays out? Do you want to play armchair quarterback on this right now?
I think it's really hard to tell, because I think it depends. As I say, I'm a little surprised it finished that short and finished with the film clip, although that can be powerful testimony. The media has certainly paid attention to that film clip. But it depends somewhat on what the defense does in terms of whether they put up any evidence, whether they put up the defendant, whether they put up the defendant and evidence.
Are you saying put up Andrea Sneiderman? Are you saying that there's a realm of possibility for that?
There's always a possibility of that. My instinct tells me the chances of that occurring here are less than 50%. At least some people are of the view that she does not do well on under cross-examination or under interrogation, which may be the very reason why she's here. She also faces a risk if she was to testify, and anything she said in this next round of testimony could be shown to be a false statement of being charged again for her testimony in her own trial.
So the perception of this may be that the defense is now faring better at this junction. Why risk it with putting her on the stand?
Right. It shifts the focus from being the state's burden to prove beyond a reasonable doubt every element of an offense to simply whether the jury believes her or not.
Back to Judge Adams.
After listening to arguments from both sides and reviewing the motion that was filed by the defense on the general demurrer, at this point, it is a well-written document. However, I'm going to deny the general demurrer at this point in time and the motion to dismiss as presented, and I will direct the state to prepare a proposed order for my signature. The remaining part of the argument, based upon issues that are beyond the court's control, we're going to go ahead and reset at this point in time. I take full responsibility for stopping early. I have no problems with that. And what we will do is we will reconvene tomorrow morning at 9. And I will allow both sides to take as much time as they need to resolve the other legal arguments. There's no time limit for anybody on any issue whatsoever. Other than that, Lord, is there anything else for tonight that we need to deal with?
All right, my only suggestion is, my only suggestion is if we're going to argue for an hour or so in the morning, perhaps we might want to let the jurors know not to come in at 9 o'clock and sit around waiting for us. So maybe we want to give them a break and if we come in at 10 if we can.
All right, appreciate it. Excellent idea. Anything else?
Nothing from the state.
All right, we're in recess till 9 o'clock tomorrow. Come on, rise.
Welcome back. I'm Jeff Hellinger along with Tom Beaver, who has been kind enough to be with us since 8:45 this morning. It's a long day, Tom. Our fee is not very good. We don't even offer you lunch, and you've done a marvelous job today. We are very, very grateful for your expertise and your analysis. So explain to us what has